we are back. We are taking up our 505 public hearing. This is a quasi-judicial public hearing to consider adoption of a resolution designating a brownfield at 9450 Southeast Gomez Avenue in Hobe Sound. This is the second required public hearing. Please proceed. Oh, first of all, any ex parte disclosures? Commissioner Vargas.
Have any, they've been filed.
Commissioner Capps.
If I have any, they have been filed.
If I have any, they've been filed.
If I have any, they've also been filed.
And Commissioner Heather.
If any, they've been filed.
Anyone who's going to be providing sworn testimony, please stand, raise your right hand, and be sworn. Anyone who's providing testimony.
Do you swear or affirm that the evidence you're about to give will be the truth, the whole truth, and nothing but the truth?
Ms. Nabe, have you sent all the required documentation to the clerk?
Yes, Madam Chair, a copy of my work history and the agenda item has been turned into the clerk.
Excellent. Please begin.
Thank you. Good evening. My name is Jenna Nabi, Senior Planner with the Growth Management Department, and before you today is a request to consider adoption of a resolution designating a brownfield at 9450 Southeast Gomez Avenue as requested by the Palms of Hobe Sound LLC and Oasis Development LLC. Section 376.80 of Florida Statutes outlines the Brownfield Program administration process and states that the jurisdictional local government shall adopt a resolution designating the property as a brownfield if the requesting party establishes that all of the necessary criteria in the statute have been met during these two public hearings. The first public hearing for this was held on December 9th, 2025, and this is the second of two required public hearings for this designation process. Brownfields are defined in Florida statute as real property, the expansion, redevelopment, or reuse of which may be complicated by actual or perceived environmental contamination. And we covered a lot of this information in the first public hearing, but I'll reintroduce it. So this property is located at 9450 Southeast Gomez Avenue in Hobe Sound, and it is 19.44 acres. This is an aerial of the subject property. It has a future land use designation of residential estate density, 2 units per acre, and 2 different zoning designations, R2 and R2B. There is currently a minor site plan application in review with the Growth Management Department that proposes 38 single-family residential units, amenities, and associated infrastructure for that development. The Florida Department of Environmental Protection, or FDEP, is the state agency that oversees and administers the Brownfields program. And so when properties are designated as brownfields and they're entered into the program, there are state-based financial incentives that are afforded to brownfield sites that are eligible for the brownfields program. These incentives are intended to promote voluntary cleanup and remediation of these brownfield sites. And brownfield sites also must enter into a rehabilitation agreement that the Florida Department of Environmental Protection is a party to that agreement. Since the December 9th, 2025 public hearing for this request, there was additional information and documentation that was requested by this board. So since that meeting, the applicant has provided an economic report that speaks to the job creation criteria. They've also sent out a letter notifying surrounding property owners within 500 feet of this public hearing today. They've provided updated notice materials consistent with the statutory requirements, and they've also provided additional financial documentation, all of which has been provided either in the published agenda or on the dais to you today. So I know the applicant can speak more to the contents of that supplementary information. But with all of that being said, staff recommends that the board receive and file the agenda item and its attachments, including the staff report, as Exhibit 1, and move that the board finds this request meets the criteria outlined in Section 376.802C of Florida Statutes and adopt the resolution designating the property as a brownfield. That concludes staff's presentation, and I know that the applicant has their own presentation as well.
Questions for Ms. Nabe? For starters, Ms. Nabe, is there a deadline for additional materials to be submitted for them to be reviewed? In other words, I haven't had the opportunity to review the additional materials. Have you?
I've reviewed them as they've come in, yes, and what's been part of the published final agenda for this meeting.
And how do you authenticate the materials that you received?
We received them from the applicant, so if they're, signed bank statements and letters and reports.
Okay, thank you. Any other questions? Applicant, would you like to make a presentation?
Good evening, Madam Chair, board members. For the record, I'm Michael Schnapps-Tyler. I'm an environmental attorney with Cobb Cole. Office is located at 1 Daytona Boulevard, Suite 600 in Daytona Beach, Florida. On behalf of the applicants here this evening, appreciate the opportunity to be here and for you all moving the meeting to 5 o'clock. It's a lot easier from us coming from Daytona Beach than if we had to be here at 9 o'clock this morning. Want to thank staff for their report and the opportunity to work with them to provide the supplemental materials that you all requested after our hearing in January. We do have the applicant here as well as someone affiliated with the company that prepared the employment report that you all have that was in the agenda, and they are available to authenticate those documents here this evening as well. I have the clicker here, so. Just by way of overview, I am going to just go very quickly through some of the background materials that were reviewed last time. I think your big concern and focus for tonight's hearing were on the job creation requirements and the financial viability of the applicant. So that's really where I'm going to focus my presentation this evening, but I'm happy to revisit any of the other things we discussed at the previous meeting, anything that's in the staff report related to the Brownfields program. But we'll also include some discussion on the next steps for the property as well. I don't think it's relevant for the actual designation criteria that applies to this evening, but it is important, I think, so that everyone understands where we are in this process and where we'll be going from here. So again, as staff mentioned, approximately 20 acres, 19.44 acres. It's a former flower nursery that had packaging and chemical storage structures out there, and the proposed redevelopment is for residential uses. This kind of shows this is a slide from last time that shows the layout when the nursery was in operation. And this is the same summary from last time of the previous environmental investigations that have occurred since 2018, before our clients acquired the property, and into 2024 as our clients have owned the property. And then this is just an overview of the residential development, the same figure that was in our presentation from the last hearing. And here are some of the renderings for the proposed residences, again, similar to exactly what we had at the last hearing. Staff covered the definition of a brownfield, and then along those lines, what's before us this evening is a request for a brownfield area designation. And so a brownfield area is just one or more brownfields that has been declared a brownfield area by resolution of the local government. So again, tonight we are here just to determine whether this property meets the definition of a brownfield area under the applicable Florida statutes. And the Florida Department of Environmental Protection, as staff mentioned, does enforce and manage the Brownfields program. And they have some fantastic guidance on the importance of redeveloping brownfields in Florida. I provided some statistics at our last hearing on this, but I just wanted to give you some information from the guidance. The guidance states that investing in brownfields utilizes existing infrastructure, increases your local tax base, it removes development pressures on undeveloped green spaces and vacant and open land. It improves and protects our environment, all while encouraging the highest and best use of blighted properties. A brownfield area designation is based on specific requirements in Florida statutes that I'll jump into very shortly. But I think it's important to review the state's legislative intent on the Brownfield program when the Florida legislature created this program, because it guides you in the decision-making before us this evening as the local government with jurisdiction over the property. So this is a direct quote from Florida statutes, the legislative intent of the beginning of the Brownfields Act. And I've just covered one of four, the first four legislative intent findings. There's, I believe, 8 total in the statute. But the first one focuses on the reduction of public health and environmental hazards on sites proposed to be rehabilitated and redeveloped is vital. It's important to their use and reuse as sources of employment, housing, recreation, and open space. And that word housing is going to be really important, and I'll get back to it later in the presentation because I think there's been some question about whether brownfields can be redeveloped for housing and single-family housing, and I'll give you some examples of projects that I personally am working on now where brownfields are being redeveloped for single-family housing throughout the state of Florida. Some other of the legislative intent focuses on how the abandonment and underuse of brownfield sites contributes to concerns about environmental equity and the distribution of environmental risk across population groups. Environmental justice is a key component to the brownfields program. The idea that underprivileged communities, minority communities, and communities in general shouldn't bear a disproportionate burden of the impacts of environmental contamination issues. The intent goes on to say that incentives should be developed and put in place to encourage parties to take responsibility for cleanup and voluntarily implement cleanup plans without the use of taxpayer dollars or the need for enforcement actions by government agencies or local governments. And finally, environmental and public health hazards cannot be eliminated without clear, definable remediation standards that provide for protection of the environment and public health, which is what this brownfield program helped establish and create. Florida statutes provides for 2 different ways to designate a brownfield area. One is by the initiative of the local government, meaning without a request of an applicant, and the second is the one that's before us this evening by the request of an applicant. Separate criteria apply depending on whether the local government takes the initiative or the applicant requests the designation. The local government designation process is open-ended criteria. It's very subjective. Will we attract redevelopers to the property? Are there portions of the site that can be used for open space and recreation? Is it a reasonably sized area to designate a brownfield area? That's done to encourage people to come in and redevelop these properties without needing to come to the local government for the brownfield area designation. And on this slide that's before you is what's called the Seminole Economic Enhancement District. It's a brownfield area in Seminole County. It's a nearly 16-mile stretch of land starting from the northern point of Seminole County, going all the way to the southern point of Seminole County, that's already been designated as a brownfield area because Seminole County and the local governments in that community took the position that we don't want redevelopers to have to go through this process if they've got a contaminated site that they want to redevelop. If you didn't cause the contamination, if you have a contaminated site that you want to redevelop, we're going to designate this large corridor as a brownfield to encourage people to come out and redevelop these sites. And this includes property that can be redeveloped for residential uses, commercial uses, industrial uses, open space. It extends, like I said, north to south throughout an entire quarter of the county. That's all these areas in blue on the figure. The areas in turquoise are the actual brownfield sites, the sites that are being cleaned up. There's a rectangle just by the airport there on Lake Mary Boulevard that we actually cleaned up for a client in the city of Sanford. The second way that a brownfield area can be designated is by the request of an applicant, which we call the mandatory brownfield area designation process, because it's for a specific project and it has specific criteria that if you meet the 5 criteria, the statute actually says you shall designate the brownfield area. So this is the beginning of the specific criteria that's before you all this evening. So if you're designating a brownfield area that's proposed by someone other than the local government, so by an applicant, the local government with jurisdiction shall adopt a resolution if, at the public hearing, the person establishes the following, which are the next 5 criteria that we're going to work through. So again, I think this one has been established. I don't think there's a question about it, but the person who owns or controls the site is requesting the designation and has agreed to clean up and redevelop the site. The applicant owns the property, controls the property, and they intend to enter into the brownfield cleanup agreement with the state if the brownfield area is designated. The second criteria is focused on job creation. So will the redevelopment of the property, the brownfield site, result in the economic productivity of the area, along with the creation of at least 5 new permanent jobs that are full-time equivalent, not associated with the cleanup, so not your consultants, and not associated with construction activities. So not, the building of the homes, the grading of the property, and all that. The job creation component does not apply if recreational areas are part of the redevelopment. We do know that there is a recreational component to this, but it's not the primary use, so we're not relying on that here before you all this evening, but I just did want to point that out to you, that the job creation criteria does not apply if you're going to redevelop the site and it has recreation as a part of it. But with the job creation and the emphasis on permanent jobs not associated with the cleanup and not associated with the redevelopment, the intent is to look at the job creation after the redevelopment is complete. Meaning, but for these housings being developed, would these jobs exist at the property? And so to verify the job creation components of this project, the applicant did hire a company, Fishkind Consulting, to prepare an employment report. That was part of your agenda packet that was submitted before this meeting. And their analysis of the number of full-time jobs created by the project divides the number of jobs into 2 types of categories. Jobs that are related to the community itself and jobs related to the specific homes, meaning people that would be helping homeowners with the maintenance and the use of their homes, or people that are helping with the community itself. So that report documents 6.8 community-related jobs for security, landscape and maintenance, and the fitness center and the recreation areas, and then 15.2 household-related jobs, so house cleaning, home, property maintenance, repairs, and things of that nature. And so with us this evening is Tony DiNardo with Fishkind and Associates. So I'd like to bring him up just to answer some questions about his report.
Good evening, Madam Chair and Commissioners. My name is Anthony DiNardo. They call me Tony, but it's Anthony DiNardo.
Mr. DiNardo, what do you do for a living?
I'm a senior associate for Fishkind Litigation and Consulting Company.
And what do you do in that role?
I analyze, I do fiscal impact analysis, I do rezoning, I do economic model analysis, and I do litigation analysis.
And what's your educational background?
I have a BA in economics from New York University. I have an MBA in accounting from New York University.
And can you talk about your employment history?
My employment history. I worked for a company I started my experience in real estate back in New York City with a company called Helmsley Spear. And I came to Florida in 1979, and I worked from 1981 to 1994 with a company called Avida. And there I was had the position of VP of Finance for the Hospitality Division. In 1994, I went to Naples, and I worked for a company called Gulf Bay Group, which developed a community called Fiddler's Creek, which is 4,000 acres and will be over 6,000 units in the Naples area. And also, we developed a lot of the high-rises in a community called Pelican Bay. After that, I retired for a year or two, and then I'm presently working with Fishkind Litigation Services and Consulting.
And have you testified as an expert witness before?
Yes.
And in what types of fields and matters have you?
In real estate development and real estate zoning.
And does that experience include property management, community management?
Yes, yes.
Okay, and you mentioned development of residential communities. Does that include high-end or luxury developments?
Yes.
Okay, great. And Tony, is this a copy of your resume?
Yes.
All right. I would just ask that, would give a copy of the resume to the clerk to be put in the record for the matter. Okay. And just to clarify, if I may ask staff, is the report already provided to the clerk, the employment report?
Yes.
Okay, all right. So, Mr. Gennardo, is this a copy of the report that Fishkind and Associates prepared for this matter?
Yes.
Okay, great, thank you. And have you seen this report before?
Yes.
Okay, and the report was prepared by your employer?
Yes.
And that's a true and correct copy of the report?
Yes.
All right. So what documents were reviewed by Fishkind in the preparation of the report?
Besides the law itself and making sure that the report adheres to the law, we pulled from the U.S. Bureau of Labor Statistics the consumer expenditure survey for households to calculate the amount of employees or full-time equivalent employees that this report encompasses, and we also used our personal experiences to come up with these numbers.
And did you also look at the site plan for the
Oh,
redevelopment?
yeah, yes, of course. You start with a site plan. I'm sorry.
And what is Fishkind Consulting's opinion on the potential for job creation at the site?
That we divided the types of jobs into two categories. One is the jobs that will be on the site itself, which is about 6.8 jobs, 3.8 dealing with security, and the rest dealing with the other amenities, and 15.2 jobs, full-time equivalent jobs, relating to the households in areas like pest control, landscaping, AC, what typical households would use at that level of value and homeowner.
And so for a community like this, so the demand created by the homes exceeds the need for one job for each of the job types you all identified?
Yes.
And were any of those jobs you identified affiliated with the cleanup of the property or the construction of the homes?
No.
And were any of those jobs associated with sales positions to sell the homes?
No.
Okay. So at a minimum, will the redevelopment result in the creation of at least five full-time equivalent jobs that are not associated with the cleanup and the redevelopment?
Yes.
Okay, and then how will the residential development add to the economic productivity of the county?
There's three segments of economic development. One, even though it's not being counted as employee for the community, there'll be the construction of the community, of the Oasis community, which will have an economic impact on the county. The permanent employees will have an impact on the county. And in addition, the third aspect is that the fiscal impact that's generated by this community would increase, because at present, the taxable assessed value of this land is $1.8 million. And after this community is completed, it'll be in excess of $72 million. So those three elements will have a positive impact on the county.
Mr. Gennardo, thank you. That's all the questions I have for you at this time. After we conclude, the commission may have some questions for you. So
Okay. Thank you very much.
So we've touched on the first two criteria. I'll briefly touch on the third criteria, which is the redevelopment consistent with the comp plan and permittable under your local government regulations? We've addressed that with staff. We addressed that at the last hearing. I don't think there's an issue here with respect to the land use and zoning. As staff mentioned, there's that minor site plan that's moving forward, 38 single-family homes, which is in line with the land use and zoning. And then briefly, as staff mentioned, we did follow the statutory notice requirements in the Brownfields Redevelopment Act, but in addition to that, we did mail notice of this meeting to residents within 500 feet, which resulted in us sending over 210 notices out by certified mail for this meeting. We followed the same process that any redeveloper would follow if they were coming before you for rezoning. We could have done 100 feet, 200 feet, 300 feet, but we went into your land development code and went with 500 feet. And then the last criteria is that the person proposing the brownfield area designation has provided reasonable assurance that they have the financial resources to complete the cleanup and facilitate the redevelopment. And so what we initially provided to you was we followed what you all did for the brownfield area that was designated in February of 2025. The applicant submitted a letter that described their history, some of their projects, their plan for the redevelopment. We submitted that to you all. We provided it to staff. As you all mentioned at the last meeting, you had some concerns about the financial ability of this applicant to complete the project. So throughout December, we provided a loan commitment for a $35 million loan for the project. There's an affidavit of authentication that is provided with that loan commitment so that you can see that it has been signed by someone affiliated with the lender for the project itself. We've provided a lot of information on existing and planned developments in Hobe Sound and other areas in Florida that our client is currently developing or has previously developed. And we do have our primary client contact here, Richard Wasserstein, who would like to bring up to provide some testimony as well. And Richard, before I get into the questions I have for you, I just wanted to state on the record that if you take a look at those financial records that are on the dais, $35 million for the loan commitment, along with the affidavit of authenticity. We do have a bank statement from TD Bank showing that the applicant has over $6 million currently in the applicant's bank account. And then we've provided statements showing funds in excess of $19 million for partners or family members associated with Mr. Wasserstein who are working with him on this development. So can you please state your name for the record?
Richard Wasserstein, 1124 King Concourse, Bay Harbor Islands, Florida, 33154.
Okay, and Mr. Wasserstein, what do you do for a living?
I'm a real estate investor and developer.
And how long have you been investing and developing in real estate?
Since 1983. When I was younger, I used to go with my father and my grandfather when they used to build and go to the different projects, and that's where I fell in love with construction.
And just generally, we'll get into specifics, but what types of real estate developments have you worked on?
I started off with single-family homes, and we built in the 80s in Surfside and Miami Beach and Bay Harbor, multiple single-family homes. And then we've veered into commercial. Back in the RTC days, we were able to acquire some commercial properties. And then from there, we've bought some warehouses. And then we've also started developing condominiums and converting condominiums to converting rental properties to condominiums. And then currently, we've gotten involved in hotels. We own Candlewood Suites by Miami International Airport. It's an IHG hotel. It's one of the top performers in the country. We built it from scratch and operate it. We are currently building Holiday Inn Express right next door to the Candlewood, which is also an IHG hotel. We just finished completing the structure and are currently doing the interior. And then in Fort Lauderdale on US 1, we're building an Indigo, which happens to also be an IHG hotel, a little higher scale. And
can you describe how the business entities that you work for are set up?
So, sometimes I'll do the deals myself. Sometimes, most of the time, we'll do it my family, my parents, my brothers, and occasionally we'll bring in outside investors. So for each property, we'll set up an entity, and depending on who the partners are.
And is it common for developers to use a specific entity, like a limited liability company, for a specific project?
Yes, it's a single-purpose entity, so you open it and you use it just for this project. You have insurance, but if, God forbid, something horrible happens, your exposure is limited to this one project.
And we provided a summary of some of the projects that you have developed to the clerk. It's on the dais there in front of you. I have this document in front of you. Can you just take a look at the document and just let us know what it is?
Yeah, these are pictures and descriptions of some of our projects. Unfortunately, I didn't keep, a very good log of every project, so these are the ones more recent. I did provide to my attorney last night. I spent going through the public records on different companies and different properties, and there was another, I think, 20, 30 properties that we've developed in the early 80s, early 90s.
Can you speak to some of the single-family residential developments, single-family homes and things that you've developed in Martin County and throughout Florida?
Yeah. So like I mentioned initially, when I graduated law school in 1986, I started developing homes. I started in 1983, but then in 86, I became more active. I had a partner who was a general contractor, and with him, we were building in Surfside, Bay Harbor. We were building upscale homes. One of the homes that we developed was sold to Julio Iglesias' daughter. Then I kept developing homes in those areas, and I joined somebody who lives in Jupiter now, but used to live in Martin County, and we built homes in Zeus Park. We built homes in Jupiter, and on Pine Tree. We built, I think it was like a 8,000 square foot home that we sold for like $4.5 million. So we've been very active in building. We try to do upscale homes, top quality homes that people will be proud of.
And can you speak to the auto art gallery that you have in Martin County?
Yeah, so in Martin County at 11700 Southeast Shell Avenue, with a local Martin County partner, we built 12 warehouses, condominiums, which people have purchased to store their cars, expensive cars and things of that nature, and collectibles. And then we're working on an office building on the corner, finishing up an office building that will also be sold.
And that warehouse space you mentioned, that's where we had the community meeting for this brownfield area designation, correct?
That's correct.
Can you talk about how you funded the capital investment in these developments that we've been talking about here this evening?
I funded it from my own personal funds. The warehouses is all my personal funds. The funds came from my practice of law for 35 years and my developing for 35 years and investing in real estate. The values, have gone crazy. So thank God I've done well and my family's done well.
I want to turn our attention now to the property that's being considered for the brownfield area designation this evening. How long have you owned that property?
It was owned in 21, it was acquired, and my company had a mortgage on the property as well as an ownership interest, and we took control of the property in about a year ago. And we hired, top architects, top designers, top engineers to develop a community that's going to be a beautiful, upscale community.
And what is your plan to fund the cleanup and redevelopment of this property?
So when we discovered that there was the problem with the dieldrin and I think arsenic, we hired an environmental consultant. I've spent with him close to $100,000 testing and trying to designate the area that has the contamination. We finally have reached the point where we know exactly where it is, and I want to clean it up. I want to remove it because I want to build a beautiful community of upscale homes. I know families are going to live there. There's going to be kids, and I want to have I want to have it cleaned. I have 5 kids myself, 8 grandkids, so it's important, for me to clean it.
And what are the funding sources you're going to use for both the cleanup and the redevelopment?
So the sources will probably, as of right now, everything that we've used has been personal funds. Pursuant to the bank statements, we have enough funds to fund the entire development. I also have a commitment letter from New Wave to lend us $35 million, which is all that we need to complete the project. I think we need to put $1 more million in, which we clearly have, and they would lend us the $35 million. I've also, while I'm on the record and I've sworn to tell the truth, we've also used Ocean Bank in the past for most of our projects, and they've already expressed an interest also in lending us the money to develop the project. Unfortunately, my loan officer was on vacation the whole Christmas. He just got back. In fact, he just sent me an email to pay for an appraisal, for another loan that we're doing with him. So Ocean Bank will also fund the project without question. But we have sufficient funds. I don't know if my counsel provided you the other letter from my brother Alan. It was dated in March. That had like 20 million.
No, we just have the more recent letter.
Okay, so there's another letter in March. I didn't need extra money, so I didn't, but there's a letter in March that we had, my brother and I and my parents and my family have in different business accounts, another $20 million available to us.
Can you speak a little bit about New Wave Residential, who they are, and what types of funding you've seen them do before?
Yeah, New Wave is located in Aventura, Florida, and there's a lady, Alexandra, and a gentleman, Ryan Powers, and we've done deals with them in the past, loans for clients of ours, and they're kind of what you call a hard equity lender. So basically, they viewed the property, they viewed the values, and they felt very comfortable. So they're a little bit higher interest rate than a bank, but there's no personal guarantee, and it's a much easier process.
And just for the record, we have provided the financial records to the clerk. They're in your packet, but I just wanted to point out that in the affidavit, New Wave Residential does point out that they have over $1.1 billion in commercial and residential loans funded since 2021. Is this the packet that we provided to the county? If you want to flip through it, I think it has, as you
Yes.
mentioned, the Oasis statement, the New Wave loan commitment, the statement for your family's funds as well?
Yes, that's correct.
Okay, great. And you had mentioned Ocean Bank. Do you have any other partners in this development currently
In
for this specific project?
just my family,
Okay. And their resources total more than 19 million as documented in these records?
far more than that.
Okay. And Richard, there's been some concerns made about the charges that were previously made against you. Has that impacted your ability to finance and develop projects like this one?
So in the beginning, obviously, it did impact me. I was unable to get any financing. The banks, because we did a lot of business with Ocean Bank, they hired their own counsel and they did a review of what happened to me. And now I'm receiving funding from them, and I'm approved by them to Ocean Bank to get any loans. And if anybody on the commission or the public or anybody has any questions about what happened, I'm more than happy to elaborate.
Okay. And the existing loans and funding that you have, that's all occurred after, the criminal proceedings you went through and all that?
That's correct. We just recently, about 6 months ago, closed on the loan for the Holiday Inn Express with Ocean Bank. They lent us $25 million for that project. We closed on a loan for the Indigo, the one in Fort Lauderdale, the hotel. We've already closed on the loan and started the construction with S3 Capital, and they're a hedge fund, and they lent us $30 million on that project.
Okay. And the financial institutions we've talked about today, New Wave, TD Bank, they all have approved loans and are holding funds and are aware of what occurred.
100%.
Okay. And just to finalize, last question here, does the applicant have the financial ability to complete the cleanup and redevelopment of the project?
Absolutely.
Okay, thanks. That's what I have for you now. So again, just to turn back to the criteria, the requirement is reasonable assurance that you have the financial ability to complete the project. So it's not funds in hand at the moment. It's have you provided reasonable assurance? And so the testimony, the exhibits, the track record, we believe all is substantial competent evidence that demonstrates that there's reasonable assurance of the ability to complete the project. And the jobs report, the financial records, our original application, the exhibits we've provided today, that's all substantial competent evidence that's been put on the record. And since this is a quasi-judicial hearing, I just wanted to share some of the case law up on the screen that talks about how the substantial competent evidence works in the context of a quasi-judicial hearing where you all are applying that specific 5 criteria to the facts that have been put on the record. So again, if someone is opposing or wanting to deny this application, they must show by substantial competent evidence that that criteria is not met. The case I cited applies to a special exception, but I think that holds true for any quasi-judicial hearing. A staff recommendation of approval is substantial competent evidence to support the decision to grant an application. That's a case from the 3rd DCA. We do have our staff recommendation of approval for this application as well. And then another case from the 1st DCA, the evidence must be beyond just a lay person's opinion to support claims of denying the competent evidence that's on the record. Moving through just to conclude here, because I know I've been talking for a while, this is just some of the same statistics on the success of the Brownfields program. These all comes from the Florida Department of Environmental Protection's annual report that the legislature requires the state to prepare and submit to the legislature. Again, $3.1 billion in capital investments in brownfield sites in Florida since 1997. Approaching 100,000 confirmed and indirect jobs, and more than 600 of these brownfield areas exist, and then 532 projects have moved forward for cleanup. And again, I mentioned earlier, some concerns have been expressed about brownfields only being redeveloped for commercial and industrial uses. I think that's contradicted by the legislative intent that I shared with you earlier that specifically focuses on housing and encourages redevelopment for both housing, open space, and recreation. At the last hearing I shared with you, a success story, City of Oviedo prepared a beautiful park on a former brownfield area as well. But I wanted to share 3 projects that I personally and my colleague Jessica Gao and I have worked on that are, true success stories in the brownfield redevelopment world. Provided a couple of articles and links here as well. These are brownfield sites that have been redeveloped for single-family residential use. We represented a developer that bought an abandoned golf course in the city of DeLand, Florida. It's the former DeLand Country Club. They signed a brownfield site rehabilitation agreement after the city of DeLand designated the brownfield area. The no further action letter, it's called a site rehabilitation completion order, was issued in 2015. And Mattamy Homes, which is a large developer from Canada, built a 155 single-family residential community called Bentley Greens. It's sold out. It's a very successful community. It's a great addition to the DeLand area. In fact, this project was featured as a success story on the Florida Department of Environmental Protection's annual Brownfield report after the redevelopment occurred. Madera at St. Augustine is the former Ponce de Leon Golf Resort located up of US 1 north of downtown St. Augustine. It's a project that my colleague Jessica and I are currently working on right now because that golf course is being redeveloped in phases. So as each kind of section of the golf course gets redeveloped, a different home builder comes in and they release a set of homes. You may recognize some of the home builders that are in there: Toll Brothers, Mastercraft Homes, AR Homes. Some of these homes are on the waterfront, so they're beautiful homes. Over 400 single-family homes in this community. We anticipate getting through and final closure on the cleanup with the last phase towards the end of this year or possibly the year after. And a project we're currently working on right now in the process of identifying the extent of the issues and working on a cleanup plan is the Bear Springs redevelopment. It's also located in DeLand. That property was acquired by D.R. Horton, which is another large home builder. They bought the property and then took an assumption of the brownfield cleanup agreement. There was already an existing cleanup agreement by a developer. They started it. D.R. Horton came in and said, we love this community. We understand the issues. We want to step into your role as the responsible party. And so we're working on the cleanup as we speak. That redevelopment plan was approved by the city of DeLand a couple of years ago. The plan is to redevelop that site for 250 single-family homes and 150 townhomes as well. So this is a very similar slide to what I shared at our last hearing in December. This is our final hearing on the proposed area designation. If the brownfield area designation is approved, the property owner plans to execute the brownfield cleanup agreement with DEP. That is the contract between the State Department of Environmental Protection and the redeveloper that requires them to complete the cleanup as if they were the responsible party. They have to follow the specific brownfield regulatory framework in the Florida Administrative Code. All of the work is completed at the cost of the redeveloper. The reports are submitted to the DEP for review and approval. There's a schedule, there's compliance requirements. It also establishes an advisory committee that we have to periodically update on the progress of the cleanup. That's very different from any other gas station site, or if the site weren't going to be cleaned up under the Brownfields program. That is a specific requirement of the Brownfield program that actually requires locals who live either in the Brownfield area that's been designated or in the vicinity of the Brownfield area to get periodic updates as the cleanup progresses and moves forward. And again, just a brief summary on how the cleanup process works. We're happy to answer any questions that you have about that. But just to conclude the presentation, we've demonstrated compliance with the 5 statutory requirements for the brownfield area designation. Our client is committed to the cleanup of a significant environmental issue under the Brownfields program. We appreciate your time this evening, the opportunity to present to you all. We're available for any questions that you have. We respectfully request your approval of the application. And I would also ask for just the opportunity to briefly address you all after public comment occurs. Thank you so much.
Questions for the applicant? I have 2 request to speak forms from the public. If you would like to speak to us, please fill out a request to speak form, hand it to the bailiff, and the bailiff will get it to me. The first request to speak form I have is from Mary Gavin, followed by Kelly Lehman.
I'm going to read because I'm trying to stay within my 3 minutes.
Sure.
And if you would like a copy of this, because I'm going to speak very quickly, just let me know, or I can email it. Happy New Year, staff and commissioners. Because I only have 3 minutes, I'm going to read my personal assessment after a lot of research, support, and information. Although this is the first residential zone property that I was able to find for brownfield, maybe there have been some, but they certainly weren't on the site, according to Scott Sweeney at the state. My concern in this case is more the fact that we do have somebody applying for tax credits that has unfortunately defrauded our state. I don't have an issue with the brownfield status. I think it's absolutely necessary. I'm more concerned with the tax credits, but that's not the main issue. I also find it a little bit appalling that I don't feel like we've received straightforward information from the owner's representative. For example, we were told that the property was not for sale and that it was removed from listings, although it had been previously listed. Contrary to what I was told, we found the listing on LoopNet, and on December 20th, I have a copy of the listing, and it was removed about a week later, I believe, after I notified Michael. He probably wasn't aware. It had been listed for over 3 years, right about the time this property was purchased by one of the current owners. I don't think it really matters, and it's kind of none of my business. They can sell it according to, the information I've gotten. But once again, this is a matter of getting straightforward information, and it would be helpful. And I think having brownfield status is probably going to help them facilitate a sale if that's where they go. Additionally, of more concern, and the biggest issue, is with the brownfield status stating that it's contained to the property. I had asked Michael for information about testing of the surrounding areas. I did not receive any. We've proceeded to do some of our own. And Unfortunately, I haven't gotten all the tests back due to the holiday, but I have gotten one that is of concern. This is county property that I was testing because it's our swale that the homeowner association maintains, and there was a DDT issue on one of the swales, which I've been digging in that dirt for years. So I do want to mention that, I guess, really, it's something that I feel like the county should be doing. When I checked into the reports to verify whether or not they were there, there's a report called Oculus. There were not any reports that my representatives and resources were able to find there regarding testing outside the property. From my personal perspective, I think the thing to do is, of course, give them status contingent on the testing of the property because the scope could change. They may need to also do some additional work in the outlying areas. The tests that were conducted are from a reputable firm, both a law firm and Geosyntec in Boca Raton, Florida. And the DDT camp.
You have 15 seconds.
Okay. Okay. I'm just going to summarize by saying I think it should be put on hold. I also want to add that Maureen Smith, who administers the tax credit program, I have an email from her stating that it requires 10 jobs to be created and not 5. And the last thing is relative to the Dade development, their program is different. Dade has their own program. I don't know if they still follow any of the state statutes. Thank you.
Thank you. Kelly Lehman is next, followed by Jan Forrest. Afternoon.
Is the overhead projector working again? It is not. Okay, I'm going to give this to your attorney, Elise Elder, to look at and maybe pass down the line if that's okay with you, Chair Hurd. Okay. Happy New Year. I am a private citizen here tonight. I have never addressed you at this microphone in this chamber. I'm here purely as a Good Samaritan private citizen, community member who cares about this area and Hope Sound in particular, family there. I am myself trying to relocate to that area when market prices maybe stabilize. And if you remember, about 2 years ago, this county commission was wonderful in asking the Florida legislature for some funds to bring the Petway neighborhood, which is just to the southwest of this parcel you're discussing, onto potable water. Unfortunately, and in that map you'll see, which I'm happy to email in as well if needed for the public record, Commissioner Jenkins, for all his might, was only able to secure funding for the west side of the railroad. So if you can visualize this, and that's what the map is, but basically the east side of the railroad, which is East Petway, there are about 24 homes who will not be able to tie in to public water. That area has a known well field that is contaminated, that is not providing good potable water for those residents. They are enveloped by public utilities everywhere else around them. So as much hard work as the county has done, I would strongly suggest, and I do not have a dog anywhere in this hunt. I do not have any property in this vicinity. I do not know the property owner. I have no clients with a vested interest in this issue. My only concern is about 25 homes that are on both sides of Petway, east of the railroad, lying about roughly 4 streets south, immediately south of this parcel. So brownfields, and I heard the word arsenic tonight. I have not had a chance to look at the brownfields legislation that was just passed in the 2025 legislation, which completely rewrote the brownfields statutes with much more incentives for development for same. So I have not had a chance to do the research that I know your staff is highly capable of doing and may have already undertaken. But I just hope that we possibly in this exercise keep in mind those 24 homes that missed under the wire being brought into the Petway transfer for drinking water onto public utilities, and that we somehow keep them in mind. And I did very briefly talk with Commissioner Jenkins, very briefly, and neither one of us could remember today if the county had had the Florida Department of Health test east of the railroad. We know it was done west of the railroad. Don Donaldson might remember where the testing occurred for those homes, but perhaps we could bring them into that testing before this exercise is final. Thank you so much.
Thank you. Jan Forrest is next, followed by Ted Johnsack. Good afternoon.
Good afternoon. Thank you so much for moving this meeting to 5 p.m. so more people could attend. My name is Jan Forrest. I live on Sable Street, which is right across from the former Flower Carnation Farm. And I just wanted to voice my opinion about that. This property was known as a flower farm. It had been there ever since we have moved to Hope Sound 37 years ago. And as an experienced developer, I feel that they should have known that there would be environmental cleanup. I'm not sure how I feel about them. I am in favor of the brownfield, but my question is that their renderings of their development does not even show the railroad tracks, and I feel like that's a little bit deceptive. I also feel like their development and the cost of the homes are not really going to be conducive with Hope Sound, our area. This is not Miami Beach. And so my question is, if the developer ends up not being able to develop the land because of the lavish plans that he has, how is that going to work as far as like if they are awarded the brownfield, or if it should just be up to them to personally, their company, clean up the land? So that's my question for you. Thank you very much.
Thank you. Ted Johnsack is next, followed by Chris Metzger.
Good evening. I'm Ted Johnsack. I live on Southeast Royal Street, which backs up to the development. I've been there since 1986. And I was at the last meeting, and I've been very involved in my community. I was president of the Homeowners Association for like 30 years, dealt with the county on a number of issues. I'm going to reiterate probably some of the things that have been already said by some of the speakers. But the concern I have in reviewing, I requested information from the county, and I was given reports. I requested it 2 months ago, and I just got the reports today, and probably about 500 pages of information. So really haven't had a chance to do really good due diligence on that. I saw who the reports are from. Specifically, one I looked at was from Hardiman and Associates, and a lot of historical information there. One of the sections shows all of the plats. This Carnation Nursery Farm started in the 1960s, okay? And it was just sold by them in 2014. So that was an active site for 50 years. And at one time, that entire site was filled with carnations. And you're only looking at one particular area where you think the contamination is contained. And I'm looking at some of the testing wells, and the locations of the testing wells. It shows them on the eastern side of the development, but I don't see any designated testing wells around the rest of the property. Obviously, if we had carnations growing around the whole property, they had to be treated with pesticides, okay? So how could we eliminate that? And it doesn't look like there was a lot of due diligence done with the previous owner. Some of the comments made in some of the reports, about limited time to evaluate them, says that they had limited contact, if any, with the previous owner. So how could you really do a valid assessment, not having talked to the owners of Sunshine Carnation Nurseries and getting a full, perspective of what exactly was done on that site? It's pretty easy to assume, because it was a nursery, that, as we've stated before, and the environmentalists have, it was designated as a brownfield site because, just being from a perspective of logic, you would think that that site was contaminated. My biggest concern is, why did we just find out that we had a contaminated site like last year? Okay, my understanding from what I reviewed, I might be wrong, but I think they knew that that site was contaminated back in 2013. Why isn't remedial action taken back then? And the bigger concern I have, I'm all for the development. Okay, I want to state that clearly. If it's done properly and it's cleaned up properly.
Sir, your time is up. Thank you. Wrap it up.
Can I make one more comment?
Sure.
One more comment. This is probably the most critical comment, and it ties into what I just heard. If they're not successful in cleaning up that site, who is obligated and responsible for that cleanup? I don't believe the county can just ignore that. You have a known contaminated site in the middle of residential developments. Somebody has got to be responsible, okay? And I'm willing, as a property owner, I've been there since '86, to take it to whatever degree I need to make sure that that site is cleaned up by somebody, because that's my biggest concern. Again, I'm all for the development, but we need to know what you're going to do next.
Sir,
Thank you very much. Appreciate the time.
Chris Metzger is next, and Mr. Metzger is the last request to speak form I have.
I live right next to Ted.
Got to speak into the mic.
I live right next to Ted in the same spot. Back in my yard is the issue that we have, And so what I'll tell you is I moved there in '86 also and raised my kids there. We picked it specifically for the way it is. I think most of the people in Hope Sound that have been there for any time at all recognize the uniqueness of it. People talk all the time about they go to other towns for ceremonies and that kind of stuff. It's unique. It's absolutely unique, okay? And we're screwing it up to make it the truth, okay? You got little areas, you got hearing the natives, you got, your business is there or was there, okay? And I just think it's atrocity. People look for this kind of places, okay? The area you're talking about, you're going to put double the amount of houses in there and everything. The road, it goes up and down there. It can't take any more traffic. It's terrible now. The bicycle guys are getting run over. I mean, it's just ridiculous, okay? I'm sorry, that's all I got to say, but I think we need to understand what we have here that people come to see. Sure, they want to move here and get who doesn't, okay? Sorry, thanks.
Thank you. Would anyone else like to address us? Back to the board. Questions for staff or the applicant?
Well, he had asked for an opportunity to rebut.
Okay.
Madam Chair and board members, again, for the record, Michael Schnapps-Tyler on behalf of the applicant. I'll keep this as brief as I can. I think the consensus of the public comment was not focused on the 5 specific criteria, but I'm happy to address some of the concerns. I think the most important one is the cleanup itself. The Florida Department of Environmental Protection is the regulatory agency with jurisdiction over the cleanup. They review every single document related to the assessment of the site, where the contamination starts and stops. They tell us, based on the reports, do you go off-site or not? Do you go test here, there, and other places? As soon as we get the reports back from Ms. Gavin when they're ready, we'll provide them to our consultants. We'll analyze them and see how it relates to the issues on our site, and we'll work together with the DEP. Since it's county property, we'll work with county staff. We'll work together on this. This is how brownfield sites are cleaned up throughout the state of Florida. There is a very specific iterative process in the Florida Administrative Code that has penalties, it has requirements, it has obligations that says these are the steps you have to take to complete the cleanup. And that's what the brownfield program requires you to do. You are signing a contract that says you are going to do this. We don't get to dictate what level of cleanup occurs. We can propose something, but if it doesn't meet the state requirements, the DEP is going to tell us, go back again, do more testing. Go back again, come up with a new plan. Go back again and go off-site. These are all requirements that happen on thousands and thousands of cleanup sites throughout Florida and more than 500 sites that are currently in the brownfield program as well. I wanted to just kind of briefly finish with talking about the tax credit program. The tax credit program is just one of many, many important aspects of the brownfields program. And that ability to apply for and receive for tax credits is based on the actual spending that is done on the cleanup. And it's defined by very specific statutes and even its own set of regulations in the Florida Administrative Code. The environmental consultants sign and seal their professional engineering and geology certifications on the line when they put the certification in for the applications. A CPA has to do an independent review of all proposals, invoices, and bank records, not just copies of checks, but the actual bank records to show that the cleanup activities have occurred, the money has been spent, the funds have been withdrawn for the account. That's all reviewed and scrutinized by the Florida Department of Environmental Protection. We are many, many, many steps away from even being able to submit the application. And the DEP is very protective of the $35 million in tax credits that they're able to issue every year, and they will deny applications. They regularly deny applications that are not in compliance with their statutes and regulations. But as I mentioned, the tax credit program is just one small part of the brownfields program that is critical in the cleanup and redevelopment of so many underutilized sites throughout Florida. We have expedited technical review, the advisory committee that I talked about, the set schedule for the cleanup, the regulatory framework. These all benefit not just the redeveloper, but also the community at large that's concerned about the environmental contamination on the site. So again, if our client does not qualify for that tax credit program, the DEP will not approve it. They will not approve it, but we will still be able to utilize those other aspects of the program that allow us to complete the cleanup of the site. Thank you.
Hold light.
I don't know who this question is for. I'm looking at the proposed soil sample sites, and I'm looking at an outline of it's an aerial of the site and also a cartoon of the site. I'm on pages 189 and 191, and I see that 60% of the property has been cultivated. So they're grow plots on a majority of the parcel, and yet the only proposed soil samples are in a very small area on the east side where it says former plant packaging and former chemical storage. Well, it just makes sense that the same chemicals that were stored and on the eastern part were used on the rest of the cultivated site. So who makes the determination of where the soil sample sites are?
I'd be happy to just briefly address.
Please be brief.
Very brief.
Yeah, this is just a snapshot in time. This is just a proposal for the yellow circles to be sampled at that specific time based on previously testing that occurred. The assessment is still in progress. We have a good handle on the extent of where the soil starts and stops. You'll see some green dots, just a few, towards the west side of the property, the north side, and the south side. Again, those are just some former soil samples from previous assessment events, but there have been other soil samples taken. This is just one small snapshot in time. The Florida Department of Environmental Protection reviews the entire history, all the historic aerials to see where the operations occurred, and then works with and provides letters and recommendations. And then, if we don't follow those recommendations, orders the redeveloper, the responsible party, to complete those cleanup activities. Again, this is just one small example of the hundreds, if not thousands, of pages of environmental cleanup reports that either currently exist or will exist as we move through the cleanup process for the site.
Well, we're not making a decision on that. We're making a decision today based upon the illustrations that we've been given, and they're unsatisfactory, I can tell you that. At least from my perspective, they are.
And if I may just respond again, we have 5 brownfield area designation criteria, and it's not what is the extent of the issues. There are brownfield sites that have very small cleanups, and they have brownfield sites that have millions and millions, tens of millions of dollars being spent. This was provided just to designate that property as a brownfield area and show that there's an existing contamination issue on the property. That's it. That's all it shows.
And for our staff, we have to make a determination about whether these 5 criteria have been met, and what do we use to determine if 5 new permanent jobs will be created?
That would be-
Are we relying upon the applicant's consultant?
We review the application materials that are submitted to us as part of this request, and if a professional report is attesting to that, then we review and make the determination based on those materials.
So we're accepting the consultant's theory that there are going to be 22 full-time jobs created with 38 homes? I couldn't buy 5, and so I'm really struggling with 22.
Paul Schilling, Growth Management Director for the record. Madam Chair, we routinely rely on professional reports and testimony within public quasi-judicial matters, so this isn't unique in that respect. The applicant could probably talk more about their job report, but from my position, as far as the department director, and in my role, I take that report as meeting the criteria.
So we don't verify.
Oh, no.
You have the expert testimony tonight.
Commissioner Campy.
Old light. I'm going to wait.
Commissioner Vargas.
You know, character is everything. Character is everything. I mean, when I saw this, I was, I'll tell you, aghast. Criminal case, sober home, takedown. You know, I'm from Miami-Dade County. I know Miami Beach very well, graduate of Miami Beach Senior High. Know it super well. You know, Bell Harbor shops is like second home. I understand all of that. The housing is exploded insofar as pricing, and I know some of the areas that you've developed. I also have a broker's license, too, for many years. I've got a lot of questions similar to what our Madam Chairwoman has, too. Who says they're going to be 5 or 10 full-time jobs, a person that you paid? Is it 5 or is it 10? I'm really confused. And my colleagues know me. I do my homework very, very carefully. And I check and I go back and double check and I test it also. So if we're talking about a quasi-judicial, do we meet all 5 criteria? I think we're lacking on that. I would not pay a full-time guard the salary plus all the benefits for 38 homes. I would not, as an astute business person and a homeowner, and you're a businessman. I see these numbers here, 5,570,000, 11 million. Let me do my math quickly. That would be about another 13 million right there, plus another 20 million. You're asking us to say, sure, let's go ahead and stamp it, but what happens when the market, the real estate market, turns down, which it's already starting to put the brakes on? I know this because I'm in the business. And I understand about hard money lenders, they're just looking to the property for collateral, not a personal guarantee. I understand that because I'm in the money business too. But permanent full-time jobs, I'm not satisfied with that. And the other thing is that normally this would be for blighted areas, so that you would be able to say, okay, this is public use, we're reclaiming the blighted areas. It could be environmentally impaired for civic and broadly accessible purposes. So here's the thing. You're looking for tax incentives. That's our money. That's our tax money. And anybody who's heard me for the last year knows I really, really will always protect the taxpayers, I being one of them too. The thing is that if you're going to be getting the tax credits, I mean, you have enough money here to do this on your own. I'm just looking at this right here. And you have an attorney and you have consultants and you've been in the business for a long time. You should be able to do this on your own. But the thing is, what's the clawback? How do we claw back those incentives? This was another issue that came before us too. It's not fun to do. It is not fun to do at all. Here comes the attorney again. Okay. But here's the thing. You are very capable of doing this. If you made a bad purchase, well, so be it. So be it. But it is on the market. I think it's for, is it $16 or $12 million? Is it still in the, but you can, I don't know. Can he come up? He wants to talk. He wants to rebut. 12, 16 million, whatever, a million here, a million there. The thing is, if you just say, I don't want anything to do with this, maybe the neighbors don't want this. These homes are extremely expensive for little old Hobe Sound, and I do love Hobe Sound, I will tell you, Commissioner Gauss. I enjoy going down. It reminds me of my old Florida neighborhoods. But we're talking almost $3 million. No place like Hobe Sound, or Jensen Beach either.
Or Palm City.
Stand in your shoe. Well, Palm City is a little more sophisticated, but anyway.
I accept.
Yeah, take that as a compliment.
I do.
Okay, remember, I'm from Miami-Dade County. I know what sophistication is. But anyway, you're talking about a spa, fitness center attendant, a pool boy, I think is what I see here, on-site landscapers, a manned gate. You know, there are communities that have 134 homes, originally planned to have a security guard there. No, it's not there. The cost is excessive, especially today. And certainly to find those positions to what your scenario is, what your creation is, might be a bit difficult. So then we're going to make a decision based on all 5 criteria met, which I'm not satisfied that particular one has been met. But more than that, why do you need the money to do this? Just write the check and do it. Just do it. Because if you don't go through with it, I believe my fellow commissioners do not want to be put in the position of chasing after money. That's not good business sense. And you know, you've been doing this a long time. Your grandfather, your father, you. As I say, I know the areas you've developed. And in Miami too, near the airport. Haven't stayed at your hotels, but I've passed by them. So that's what I have to say about this right now.
Commissioner,
Come back again.
Commissioner Campy.
Thank you. There's a lot to unpack here. The presentation, the comments from the owner, the public comments, our staff. So let me try to capsulize it as best I can. In regards to using the program, the reason you're here today in the first place, it's not a Martin County program, it's a state of Florida program. It's a tax credit program and a policy that the state put in place for the entire state to take advantage of. So I'm not, as a shrewd business person, I see no reason why you and hundreds of other people in the last several years have taken advantage of a bona fide, legal state program. I don't care if you were Elon Musk, if, smart business people are taking advantage of programs that are available. Back to our local residents, a couple of points were made during the public comment, and I was very careful to listen, and I appreciate you all coming out, and I appreciate the people that speak so that we can get a better understanding of what's happening right there. I will tell you, during today's lunch break, I drove down, looked to see if the property was cleaned up, and it was. Drove down both the streets, the dead ends on both sides, north and south of the property, gorgeous, both, and then I went across the street as well. Beautiful neighborhoods, obviously not blighted, which is fine because this property is blighted. I'd also remind you and my newer colleagues that several years ago, when this property was set to be redeveloped, the skies opened up and people came and were very well organized, and we denied it. And the property has sat with the contamination on the site for the years since that happened. It's not going to get any better. These are probably generational kind of issues that, if left untreated and taken care of, it's dangerous for you all. And when you go to sell your own beautiful homes, you're going to have to explain, or your realtor is going to have to explain. I think by law, you got a couple of realtors up here. I don't think you can keep that a secret from potential buyers. So I think the sooner we get it cleaned up, the better. And there have been, I don't remember the last group that was looking to develop that property coming forward and talking about the brownfield program. I don't remember we didn't get that deep into it at the time, but we didn't even start to talk about the contaminations. So if you finally have someone who's willing to come forward, obviously bought the property knowing it was contaminated, it's a Carnation Farm. And I'm not an expert, but I'll tell you, we had the exact same situation in Palm City on Berry Avenue with the exact same company. It was Sunshine Carnation Farms. And we didn't discuss brownfield, and there wasn't a lot of talk, if I can remember, and I have a pretty good memory of contamination, and that's a beautiful neighborhood now. Much less, very pretty homes, but not to the scale of the homes that would be appropriate in your neighborhood or would be appropriate. So, and I also heard very carefully the neighbors didn't say, actually they said the opposite, I'm in favor of the project. I'm in favor of the brownfield cleanup. So I'm wondering where the controversy is or where the animosity is here, because I've heard the neighbors very respectfully say, look, we're not opposed to the project and we want it cleaned up. Well, there's a guy that's willing to clean it up, and he's allowed to take advantage of a program that exists for everywhere. You saw that one picture, 16 miles in Seminole County, and then he showed, the only knock I'll give you is you talk, and this is coming from me, your presentation too long. I get you, you're trying to put it all on the record, I get it. But that being said, the property was not contaminated by its current owner or his representatives. Those people escaped. They contaminated the property and then they left. Now, like I said, I'm not an expert, but I have been involved with some folks that were looking to purchase property here in Martin County many years ago, and they had to do their due diligence because there are flower farms all over Martin County. It's the chrysanthemum capital of the world. So I had a friend who was looking at some property, and he had to go through the level 1 inspection, the level 2, and where did you pick and choose. It would make sense as a layperson that if you put go back to the one that showed what it used to look like. This one. I mean, you don't have to be, Perry Mason to figure out former chemical storage area. We're talking about the content, like the level of contamination. If they're spraying whatever they were spraying onto the flower on the grow plots versus letting it soak out a gallon of rusty containers or buckets, or filling equipment and sprayers at that location and it's just seeping into the ground, I understand why it might not be contaminated all over the place, and it is very much concentrated right there. So now we start looking at, his history and his criminal background. That was interesting to hear the last time we did. But I think between, we're not the moral police and the judge and jury up here. And he was willing to tell the story, and I was cringing when he said it because I don't want to hear the whole entire story. We read through the information that was submitted, and I appreciate it. I have it in my mind. I thought about it thoughtfully on whether or not I would, deny the entire project because of his history. I won't. In terms of the questions that I ask, and if you go back and watch, I was the one that was saying, I want this and I want that. I wanted you to notify the neighbors beyond a sign that maybe some people saw and some people. You notified, what you say, a couple hundred people? 500? Oh no, 500 feet, a couple hundred people. I checked that box because our responsibility is to make sure that the impacted parties are at least aware. And you did that. I thought, well, if you're trying to come here and ask us to do something for you, at least shape the property up. The signs were the grass was tall. I specifically drove down there today to see if you did it, and you did. In terms of the employee count, look, 15, 20, 25, I have no idea. But the requirement from what we have heard from our staff and from you is 5. Now, Mary said that she got an email that someone says it's 10. I didn't see the email. But let's say that's fine. Yeah, and it's fine. Look, we're not experts, but we got one in the back who's obviously qualified. He read his whole resume to us. And when Mr. Schilling says that, hey, we rely on, and I wrote it down, outside consultants and professionals come with every application. Environmental consultants, lawyers, traffic consultants. We don't then say, well, I don't know if you're a traffic consultant or not. That guy gave his resume, and that's what we required of you. Now, if you don't, in terms of will you have a manned guard gate in front of your 38 homes? If they're $1 million homes, it's not impossible to have that. Some people will love it. It's gorgeous. I mean, the soundings and across the street, it's beautiful down there. It's probably one of the nicest areas in Martin County. All in a row. Gomez is gorgeous. He said yes. I got to take him at his word. I don't know more than he does. He said yes. He's staking his professional reputation, and he signed the letter. In terms of if he can raise the money or not, look, we could say that to every applicant that comes forward. You showed a letter that said you could afford to buy the property today. 3 months from now, you sell it, you don't sell it. I don't care. My concern is for the constituents and the residents. What's the ultimate goal? Clean up the property. I mean, you don't have to be a biologist or a scientist to realize the first thing we need to do as quickly as possible is clean up the property. We've only done brownfields very recently, and it's been 2 in like the last 6 months. We didn't grill the other team that hard. We were just glad they were cleaning up the property. And that was on the canal, and you're not on the canal. You're close on the other side there. But I would clean it up for the residents, for the people that live adjacent to it. You have deep properties. And so at the end of the day, let's get the property cleaned up. If you want to start figuring out what does the architecture look like and that's down the road. And the last thing I'll say is that this is a quasi-judicial, which gives us sort of like judicial kind of responsibilities. And I know you tried to lay it out there very casually, but by the way, it's like, listen, this is legal precedent that's been set. These are court cases that have been solved. Our staff, which did have time to review all the documentation, which have decades of experience and collectively probably centuries of experience, reviewed this, and what did they say to us, their job? Yes, we agree that it's been handled. So if 3 of us decide today that we shouldn't, I think, and I always tell people, I'm not afraid of the county getting into a lawsuit. I'm afraid of the county losing a lawsuit. Our staff that we task with telling us, do you think this is up or down? They said up. We saw the finances. We got the guy with the 5 jobs. We're guessing if there'll be 5 jobs there or not. But the final thing to my colleagues is this. We're not going to have to claw the money back from the applicant if they don't do what they're supposed to. It's a state program. The state is going to come looking for their money back. The state's going to hold their feet to the fire to see if they do what they're legally required to do. So when I put those things together, even if at the last meeting I left thinking I'm a no, I think I have to be a yes, because at the end of the day, we're looking to clean the property up, and I think they've met the burden of at least getting them to the next step. And then when we get into the fact of, do you like the house? If this wasn't contaminated, would this size project even come to us?
No, and it won't.
No, sir. It's 38 units proposed, so it's under the threshold of a major
If
development.
it wasn't contaminated, we're not even having this conversation. So I'm focusing most of my attention on how do I clean up the contamination for you? And we got a guy that's willing to do it. Let's make sure he does it, but let's give him the opportunity to do it. Because if it's not him, there's no one else coming behind him. Thank you
Commissioner
very much.
Hetherington.
I will, number one, I can empathize with the residents. I'm a 4th-generation native, and I know it's changed, and it's hard to see, especially when it's going literally, the 2 gentlemen in your backyard. And whether it's out of character for the area, in this particular determination, I'm only looking at the brownfield, because that will come, and clearly it will not come before this board, but the 5 criteria, have they been met? So number 1 was ownership. That's certainly been met, in my opinion. Jobs. My question to Ms. Elder is, if there are questions on the expert, what's the legal requirement for someone to produce this information? And is it 5 jobs or is it 10 jobs?
So under the statute, it's 5 jobs. So they have to establish by competent substantial evidence that this project will create 5 jobs. They brought in an expert economist to do that. So if the board, for some reason, doesn't find him credible or doesn't find the evidence he provided credible, that would be the only way for you to deny it if you found it not to be credible evidence, because the county does not usually provide evidence in response to contradict an applicant. And I think staff evaluated the evidence and determined it was credible, but the board can make that determination on their own if the expert was credible. And Commissioner Campy said you look at his work history, what he's done in the past, what kind of expert he is, and things like that to determine if he has the credibility and the skills to make this determination.
Okay. And then 3 was, does it follow the local comprehensive plan, which staff says it does? And 4 was the notice, and you've gone above and beyond the notice. And number 5 was a reasonable assurance of the financials being met. And I don't believe that was the case the last hearing, but I do believe that reasonable assurance has been met in this particular case. And so I believe in this particular hearing that those 5 criteria, and I think Commissioner Campy mentioned this, no one wants to be in a lawsuit, but we certainly don't want to be in a losing lawsuit for our residents. So I'm inclined to support this brownfield area. And I have one more question. So if it was never designated a brownfield area, it would still require cleanup, correct?
Correct. So the applicant can still clean it up whether or not it's designated as a brownfield. If they want to develop it, it has to be cleaned up.
So regardless if it's designated, once it's cleaned, it's eligible for whatever the county deems is legally acceptable to develop it.
Correct.
Commissioner Capps.
I want to thank my fellow Hobe Sound residents for coming out and speaking about this. I share your concerns. I live about a mile south of the project off of Alabama Place. So I think our main thing is we want this cleaned up. And I appreciate what everyone has had to say, and I think you've added tremendous value to the discussion. This is a quasi-judicial hearing where the legal standard is competent substantial evidence in the record. It's a state program. There are 5 very clearly laid out criteria. And it seems to me that there were 2 issues going in. One had to do with sufficient financial resources, and it appears that there's that requirement is met, and that we have reasonable assurance of adequate and sufficient financial resources. And then the only other issue really in play, it would seem, is whether 5 permanent full-time equivalent positions are satisfied. You know, at first when I thought, I was a little concerned about this because I thought, is a 38-home community going to have 24/7 security with 3.8 workers involved, and for a community that small? You know, I've been to a lot of gated communities in Martin County, and that would seem questionable to me as to whether you're your homeowners association is going to keep that much staffing for security for a community that's that small. But when it comes to this 5 full-time equivalent permanent positions, if we look at the criteria on page, let's see, if we look at the full-time jobs created by Oasis Hope Sound on page 230, 234, and then you look at these tables, like on page 237. Well, let's see, we've got 3 tables. Table 1 is gate staff, 3.8 workers, and then table 2 is household staff. And that total comes to, well, they don't have that totaled up, but, yeah, 3.8, yeah, down at the bottom. And then table 3, permanent jobs supported by the project. And until I read a little deeper, I didn't know you could count all of this, but, you got house cleaners, pest service, AC maintenance, spa, fitness center, landscape pool maintenance, gate guards. It comes to a grand total of 22. So it's not really a close thing. I mean, like, if we were really worried about whether the security guards were critical in order to meet the 5-person requirement, but it's not even close. I mean, if they have competent substantial evidence that shows 22 FTEs and all we need is 5, they're way over that number. So I think that allays my concern about the 5 worker requirement. So it seems to me that the requirements are met, but I really appreciate everything that everyone has said that gives further light on what needs to be done with this project going forward. And I look forward to seeing it coming to fruition and allaying everybody's concerns in Hope Sound, and I have those concerns as well. So I will support the designation of the brownfield here tonight.
Commissioner Vargas.
No, I think that I've said what I had to say about this enough. It can be cleaned up without being designated as a brownfield. I don't know how many people are going to be spraying for bugs, but I'd be more concerned about that, I see the number of hours here. The pool, I mean, the fellow comes once a week. So there's a lot of inconsistencies, inaccuracies here. And it's not that my heart doesn't go out to those folks in the area, but we have to be careful. Are we going to be consistent or inconsistent? My fellow commissioners, some have been here longer than I have, and they need to come to that determination because people are watching. Martin County taxpayers and residents are a very astute group of people, very astute. And I get the calls because they say there's nobody else to speak to. So I hope this changes this year.
Commissioner Campy.
Thank you. I just wanted to bring up the point that another public commenter had made about the east side of the railroad tracks for Petway. If separate from this, obviously has nothing to do with this, but while it's being mentioned and while we're discussing it, I'd like staff to look into seeing what would be the case. I do remember when that came up originally, I didn't realize that the outcome was half. One side of 95 of the railroad tracks was yes, and the other side was no, as a separate thing. And then in regards to our taxpayers, the project is currently bringing in $1.2 million in taxes, taxable value, and then it'll be as a fully built-out, beautiful neighborhood in conjunction and appropriate to the rest of the surrounding neighborhoods. It'll bring in multi-millions of dollars. So I think our taxpayers, as well as the fact that we're cleaning up a contaminated site in Martin County, I see it as a win. Thank you. So I guess we're all dancing. I'll make a motion to accept staff's recommendation.
Second.
Commissioner Vargas?
We are assuming that the taxes will be brought in. This is a year when there's going to be strategic change with ad valorem taxes. So to hang your hat on the same argument may not carry water, and if the market has a downturn, I think that the gentleman will definitely say, wait a moment, maybe this is not the right time. So I think we really need to look a little deeper than just making the same comments we've made for the last 16 years. So.
There's a motion and a second. All those in favor? Aye.
Aye.
Opposed?
Opposed.
That motion passes 4-1 with Commissioner Vargas dissenting. That brings us to the end of our meeting. I'm just going to generally ask if commissioners have any comments. You'll feel free to refrain.
I just wanted to make an announcement on 2 events that we're having in Palm City. On January 15th at 8 a.m. at the Palm City Community Center, I'm having Dish with the Commish with our sheriff, Butenseek. We're going to discuss a lot of the issues that Martin County residents have questions for him. 8 a.m. on Thursday, January 15th, and then on Saturday, January 17th at 6 p.m., we're having music in the park on Map Road, which is right next door to the Station 21 Fire Station. And with that, I appreciate it. Those are free events.
Any further comments? Nope. We are adjourned.
Thank you.
Thank you.
Thank you.